Did you know that your YouTube channel name and/or your YouTube handle name may be your trademark? Hello and welcome. I'm trademark attorney Eric Kelly, and I'm going to discuss what this means for you as a YouTuber, content creator, and/or influencer. Because your YouTube channel name and/or your YouTube handle name may be your trademark, that has at least two important main possible legal implications for you. First, you want to pick a channel and/or handle name that is not likely to infringe the rights in a pre-existing, confusingly similar trademark of somebody else. That is, you want to pick a channel and/or handle name that is not likely to get you sued for trademark infringement. And we'll go over some pointers with respect to that. And secondly, you want to pick a channel and/or handle name that is more likely to be protected as your trademark. That is, you want to pick a channel and/or handle name that can be protected as your trademark, so that if someone ever infringes your trademark, you'll have the legal right to stop that infringement from happening. Next, we're going to just kind of look at some of the basic legal definitions of what a trademark is, so you can understand how that relates to your channel name and handle name. And then we'll kind of look at more of a layperson definition for what a trademark is, because I think the legal definitions can be a little bit awkward and confusing to really understand. So to look at the technical legal definition, we'll look at the federal statute that spells out what a trademark is. And that's found under Title 15 of the United States Code, Section 1127, which is, we can look at that particular language right here. And I'm going to do Control F here just to find the trademark definition. And again, this is the legal definition, and the federal legal definition of what a trademark is, and it's a little bit awkward and kind of clunky. So the term trademark includes any word, name, symbol, or device, or any combination thereof, one, used by a person, or two, which a person has a bona fide intention to use in commerce and applies to register on the principal register established by this chapter, to identify and distinguish his or her goods, including a unique product, from those manufactured or sold by others, and to indicate the source of goods, even if that source is unknown. So that's the technical legal definition of what a trademark is under U.S. federal law. And again, it's awkward and kind of confusing language. A little bit better definition is one provided by the United States Patent and Trademark Office. We'll look at what their version of what a trademark is next. So go to USPTO.gov, which is the federal government website for the United States Patent and Trademark Office. We'll head over here to trademarks, then we'll look at trademark basics. And then we'll come down here to what is a trademark. So this is the USPTO's slightly dumbed down version compared to the actual federal statute we just read. A trademark can be any word, phrase, symbol, design, or a combination of these things that identifies your goods or services. It's how customers recognize you in the marketplace and distinguish you from your competitors. And this is, I think, a decent point to make here as well in the second paragraph. The word trademark can refer to both trademarks or I should maybe say and or service marks. A trademark is used with goods or products, basically, while a service mark is used in relation to services. So next we'll go actually kind of to my informal definition of kind of what I think is a little bit more useful way of thinking about trademarks. So this is kind of like my informal version here. A trademark is something that allows a person to have an instant mental connection or impression to at least one product or at least one service that is associated with that trademark. And often along with that kind of thinking, the instant that mental impression is made, You also generally have your own personal thoughts as to the quality of the associated products and or services. So as an example, if I just show you the word Nike, you likely have an instant mental connection or some kind of association. You probably are thinking shoes, Nike shoes, Nike clothing. And you also probably have your own personal view as to what you think that is the quality of those products. So that's an example of a trademark because Nike is associated with products or goods. So for example, if I just went over to, did a basic Google search of Nike, we're likely going to see shoes or Nike clothing. Again, boom. If just from a Google search of Nike, obviously you see a bunch of Nike shoes, right? So that's what a trademark does. As a consumer, when you see it or hear it, assuming that you know what the trademark is, you're familiar with it. As soon as you see it or hear it, you're going to have that instant mental connection of whatever the associated products or services are. So let's do another example. This one will be for a service mark. So if I just show you the word Target, you're going to have that instant mental connection with, the company Target, which is this large national retailer. So for example, if we do a Google search just for Target, we're largely going to first see, this Target as the retailer here, right? And so Target is an example of a service mark, which going back to that USPTO definition, you can just call it a trademark for all practical purposes. But the reason it's a service mark is because what the service Target provides is it's a retailer, whereas what Nike's providing are the actual products, footwear, for example, that are branded as Nike. So going back kind of to my intro slide, where I kind of make the point that your channel name or channel handle is basically operating as your trademark. So how does this trademark idea work in this realm of your channel name and your channel handle? So let's give you another example. Let's look at this word here, Mr. Beast. So when you see or hear Mr. Beast, what do you think of? If you're a YouTuber, you probably would instantly think of the person and the channel associated with the Mr. Beast YouTube channel, right? So for example, if we go over to YouTube, right? So if we go over to Google and go to YouTube, and we bring up Mr. Beast, we're going to see the Mr. Beast channel, right? And so that channel name and the handle are operating as a trademark, because when we talk about it, we have this or see it. We, again, as a consumer, you'd have that instant mental connection of a product or service being associated with Mr. Beast. And in this case, it's generally a service, and that service happens to be one of entertainment. So for example, just kind of bringing that kind of concept home, if we go back to the USPTO.gov website, we're not going to do a survey right now. Oh, so if we're going to the trademark area and we do searching trademarks, click here and just do a basic search. If I enter Mr. Beast, and you see a number of Mr. Beast trademarks. So just clicking Mr. Beast. So you'll see here in International Class 41, entertainment services. So that's basically, so technically that's a service mark with respect to Mr. Beast. Now over here, just as an example, you see International Class 25, that's for clothing. So it looks like Mr. Beast is also selling clothing branded under Mr. Beast, which is very common and typical for YouTubers. So now that we understand that a YouTube channel name and handle name can actually operate as a trademark, we're going to go through 4 things you should try to avoid doing when picking your channel name so as to not get you into trademark law trouble. So here's the first of 4 basically things you want to avoid doing when picking a channel name or handle name. And the first one is you want to avoid picking a channel name or handle that is the same or similar to any famous brand. Basically, you don't want to use a famous brand or something kind of similar to a famous brand as any part of your channel name or handle. Because if you do, you could potentially get sued for something called trademark dilution. And you basically, obviously, you don't want to be getting sued, especially by a famous brand, because famous brands like Nike, for example, or Target, they have tons of money, and so they have the bill and lawyers, so they easily can sue you. So it's something you want to avoid if you can. Okay, next we'll look at a second thing you want to avoid doing if you can when you're picking your channel name or handle name, and that's picking a name that is entirely descriptive with respect to the type of content you plan to have on your channel. And the reason behind this one is descriptive trademarks can be very difficult to impossible to establish and protect. So just as an example, if you were to name your channel DIY plumbing as your channel or handle name, and your content was all about DIY plumbing, then that would be a channel name or handle name that would be difficult to impossible to protect as a trademark, because your channel name is describing exactly the type of content what you're putting out. And the reason that's hard to protect as a trademark is that anyone else who's making content about DIY plumbing needs to use those words DIY plumbing to describe that content. And so it wouldn't be fair to others for you to get a trademark on DIY plumbing. That's why you want to avoid having a channel name that's entirely descriptive with respect to the type of content your channel will have. And when I say entirely descriptive, it's okay if maybe 1 or 2 of the words in your name are descriptive, as long as you have some other words in your name that are non-descriptive. Again, and we're talking about descriptive here, it's always with respect to your content. Okay, so now we're going to look at a third area where you really want to avoid when you're picking your channel name, and that is you do not want to use the name of somebody else or use the likeness of somebody else in your logo, for example. Because if you use someone else's name or someone else's likeness without their permission, and you're using it for commercial purposes, like for example, if your YouTube channel gets monetized, then you can basically find yourself getting sued for violating that person's publicity rights. So for example, in every state, to my knowledge, has some law on the books dealing with publicity rights. For example, in California, there's several. In California, you can look up California Civil Code 3344, which basically says, or at least a portion of that law says, any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner on or in products, merchandise, or goods, or for purposes of advertising or selling or soliciting purchases of products, merchandise, goods, or services without such person's prior consent, or in the case of a minor, the prior consent of his parent or legal guardian, shall be liable for damages sustained by the person or persons injured as a result thereof. And there's some exceptions to this rule, but generally you don't want to use somebody else's name or likeness for commercial purposes. So that's another area when you're naming your channel name or handle that you want to avoid. You might be able to use your own name, and we'll get into that, but you generally want to avoid using someone else's name. And here's the last point I want to bring up that you want to try to avoid doing. You want to avoid picking a channel name or handle that is the same or confusingly similar to a pre-existing trademark that provides the same or similar services. And this point, it's important, but it's also kind of the hardest one to check, because really the only way to evaluate this is to have some type of due diligence clearance searching done. So when you're thinking of a name, before you actually adopt it and use it, in theory, you should search for that name to see if anyone else is using it. And if they are are they using it for the same products or services that you're going to be using it for? Now, if you find other people are using it, but it's for something totally unrelated, then you may be absolutely fine moving forward with it. And in theory, or legally in theory, you should have your trademark attorney run that type of search so they can do the proper legal analysis. This is legally optional. Most people don't do it, but it is recommended. Okay, so next we're going to look at 4 possible ways that you should consider naming your channel or handle, as these are ways that could lead to good trademark protection for you. So the first thing you could consider doing is actually just using your legal name. Your name, first and last name, could very well operate as a trademark, as long as someone else isn't using that name for the same or similar products or services, which kind of gets back to our last point about avoiding confusion. And just as an example of someone's personal name operating as a trademark, we'll go back over to the USPTO and we'll do a search for, let's say, Taylor Swift. And again, you can see here she's got a ton of trademarks in her name, right? And not all these are going to be with respect to music, because she has other products that she's offering. But just to illustrate that your name can operate as a trademark, even if it's not a real legal name. Let's say it's a stage name, it still can operate as a trademark. So another example of a famous name here. Let's say Ariana Grande. Again, you can see she's got her name trademarked, right? And her first one here, just as an example, goes all the way back to 2008 is when she first did. And this is, again, Class 41 for entertainment services. So in the YouTube area, personal names as channel names are very common, and that can be a perfectly fine trademark, as long as no one else is using that name for the same products or services. So just as an example, we'll look at Mark Roberg, 23 million subscribers, so obviously well known, right? And then again, if we go back over to the USPTO, we do a trademark search for Mark. You can see he's got 2 trademarks here filed. This one that doesn't have a registration number, but does have a serial number. This one's pending, and I would imagine it will become registered shortly. But again, you see Class 41. This is going to be, again, for things like educational services. And for Mark in particular, not only is it for entertainment purposes, but also education. So that goes back again to our first point of things you could do to name your channel that could also result in good trademark protection. That's using your personal name. But again, the caveat there is that you can only use your full name as your channel name and as a trademark if no one else is using it for the same or similar products or services. Which then brings us into our next suggestion, which is to use your first name or last name and then combine that with at least one other word, right? So you have at least 2 words in your channel name and or trademark, one of them being part of either your first name or last name and then some other word, right? So there's tons of YouTubers that do this, right? So just as some examples, you can look at Linus Tech Tips, Preston Plays, Gone with the Winds, Blake's Exotic Animal Ranch, Crypto Casey, Aaron on Demand, Miranda in the Wild. These are all YouTubers that are following this kind of point where they're using at least their first or last name and then at least one other word. And so we'll look at Linus Tech Tips just in particular here. So, right, obviously Linus Tech Tips, right? YouTube, right? And then we can go back to the USPTO and do a search there to show you that is a trademark. So here we go, Linus Tech Tips. So then we'll look at a third example of a way you can potentially name your channel, and also that would work as a potentially good trademark. And that's to come up with some kind of catchy, cute, what we call kind of like in trademark law, we call it a suggestive name. And this is slightly different because if you recall, in some of the 4 things not to do, one of the things not to do was to use an entirely descriptive name. A suggestive name and a descriptive name are similar but different, and the distinction between the two is not always crystal clear. But a suggestive name is something that's not quite descriptive. So descriptive names tend to be weak trademarks, whereas suggestive names tend to be strong trademarks. And just as some examples of YouTubers that I think kind of are following this approach, we have Plantarina, again, Gone with the Winds, Demolition Ranch, Electrician U, The Slow Mo Guys, Project Life. So there's a bunch, right? So we'll look at Plantarina just as an example. So we'll go to YouTube, right, and verify that that's an actual YouTube channel. Right, Plantarina, she almost has 1 million subscribers, right? And then we'll go over to the USPTO.gov website and we'll do a trademark search for Plantarina. And again, you can see she's got a number of trademarks here. And so going back to her YouTube channel, you can see that her channel is about plants, right? And she's got the word plant in her name, but it's not just plants, it's Plantarina. So she's kind of made up this word, but it's still built off of that concept of plant or plants. This is why I would call this a suggestive mark. So when you see the word, the made up word Plantarina, it suggests it has some kind of connection to plants. So this is, I would say, something that's not descriptive, but suggestive. And suggestive trademarks can be very strong. Okay, so this leads us into our fourth and final suggestion of a possible way to name your channel that also could potentially make for a strong or good trademark. And that's to use what we call an arbitrary, fanciful, or made-up name. And arbitrary or fanciful or made up, this is with respect to your content. So I think probably the most famous example here would be Mr. Beast. So if you look at Mr. Beast, that doesn't describe his content, and I don't think it necessarily suggests his content. So I would say the relationship between his content and the name, I would say, is arbitrary. And arbitrary trademarks are ones that are particularly strong. So for example, the trademark Apple. Apple does not describe consumer electronics, right? So the term Apple is arbitrary with respect to its associated products. Just like here, Mr. Beast as a trademark is arbitrary with the content of his channel. Perhaps you can make the argument that because everything he does is so extreme that maybe Mr. Beast is suggestive. In any event, we've already looked at Mr. Beast on YouTube and on the USPTO, so we know that Mr. Beast has a name. So we can look at another example. How about guava juice? So we'll go back to YouTube and search for guava juice. Right. Here's guava juice, approaching 17 million subscribers. Guava juice, is run by Roy. It's not obviously about guava juice. Again, that's why the name is arbitrary with respect to the content, and that makes for a strong trademark. Okay, so we've touched on 4 things you should avoid doing and 4 things you could consider doing to pick your channel name and also potentially give you a good trademark in your channel name. So now we're going to look at just a quick disclaimer here from me. So note, I do not represent, nor am I affiliated with, sponsored by, endorsed by, and or connected with in any way whatsoever with any of these YouTube channels, trademarks, and or brands mentioned in this video. I was merely showing examples of some YouTube channels that have registered their trademarks in those channel names with the USPTO. Okay. Now, one of the reasons I mentioned this disclaimer obviously is to protect myself, but I'm protecting myself from trademark infringement, because with my disclaimer, it should eliminate confusion in the minds of consumers, right? And if you can eliminate confusion, then you're generally eliminating your liability for trademark infringement. So now we're just going to kind of hit on a summary of what we mentioned here, right? 4 things to avoid doing and 4 things that could possibly work well for picking a channel name that would also yield a good trademark. So just recapping on things to avoid doing when you're picking your name. You don't want to use anything that's the same or similar to a famous brand in your channel name, okay, or handle. That could lead to getting sued for trademark dilution, so don't do that. Additionally, don't pick a name or handle that's entirely descriptive with respect to your content, because that can result in a name that you can't protect as a trademark. And so you won't be able to prevent other people from using those words. Number 3, you do not want to use the name or likeness of somebody else without their permission for commercial purposes. Again, that can get you sued for violating their publicity rights. And fourthly and lastly, you ideally, whatever name you settle on, you should, before you adopt and start using it, you should in theory do some searching to make sure that whatever you're trying to move forward with is not confusingly similar to a pre-existing trademark for similar products or services. So in theory, if you were to use any one of these 4 possible suggested ways of naming your name, whatever one you use, and then whatever you come up with, in theory, that should then be run through a search to avoid this 4th problem over here. So again, looking at the 4 possible ways to pick a name that could also yield a good trademark for you, the first way to go would be is to possibly use your personal name, right? That could work, but the caveat there is it'll only work as long as no one else is using that name for the same or similar products or services. Second approach would be to use your first or last name with some other word, and maybe that other word is a descriptive word. That would be fine. Another third approach here that you could do is to come up with a suggestive name, something that might suggest your content but not describe your content. And the example we used was Plantarina. And lastly, the 4th method here would be to come up with either a made-up name or a name that's basically arbitrary with respect to your content. And the examples we used there were, for Mr. Beast or guava juice. All right, so assuming that you go through this process, you pick your channel name and you do it in a way that it can hopefully be a good trademark for you, how do you actually register that trademark? And again, so we'll go back to the USPTO website. And we'll start from the home page of the USPTO. We'll go from trademarks, and we'll look at their trademark fees, so you can get an idea what the fees are, all trademark fees, application related fees. And so really what you're looking at for filing are just one of these two. So you're either going to be paying $250 per class or $350 per class. So these fees are on a per class basis. So I don't know if you recall, but when we looked at like Mr. Beast's trademark, and he was registered in class 41, and he was also registered in class 25. So he was registered in 2 classes. So whichever fee he paid, he would have got hit twice because he's in 2 classes. Now the difference here between the $250 per class or the $350 per class, this really reflects whether or not, when you're describing your associated products or services, and generally for a YouTuber, it's going to be a service and generally the nature of entertainment. When you're describing what it is you do, how, your service that's connected to your trademark, if you write your own custom language to describe your services, that's the $350 per class pricing. Whereas if you can describe your services using a pre-existing category of language, and that is accurate for you, then you can use the $250 pricing. So let me show you what I mean by this. So again, we'll just go to the USPTO.gov. We'll do a trademark search, again, just for Mr. Beast, just to use as an example. So he's in two classes, class 41, class 25. So either the $250 pricing or the $350 pricing per class would be applied twice to the filing, because he's filed in two classes. And this is the language that's being used to actually describe, right? Entertainment services, namely providing online non-downloadable videos featuring stunts, pranks, challenges, and monetary giveaways. If that language was already pre-existing in the USPTO's database, then the $250 per class pricing could apply. But if he had their custom come up with that language, which he did, then it's the $350 price, $350 per class pricing would apply. So to check, here I'll copy that language, and to see if that language is pre-existing or not, you look in. We'll go to the USPTO.gov, and in this search field, we're going to put ID manual search, and then you're going to look at the trademark ID manual, and whatever language you're looking for, you'll enter into the search field. So if I enter whatever Mr. Beast had, so this is long. It's not going to show up if I run the search because there's too many words here. But just to show an example, no records found. Right, it's too long. So his language was custom written, so the $350 per class pricing applied. But if you look up just entertainment services, let's see what we can get. So that's, oh, there we go. You can see there's a bunch in class 41. So if you were to, you know, just as an example, if it was cabaret entertainment services, and that's what your associated services were with your trademark, then you could use this pre-existing language, and the $250 per class pricing would apply. Now, generally as YouTubers, because you're always going to be doing something unique, you're probably going to have to write your own custom language here. So I think by and large, the $350 per class pricing is going to be the one that's applicable here. And note these fees that are listed on the USPTO, they do change from time to time, so they might go up or down, you know, in the future. So keep that in mind as well. And then we'll wrap this up. Just look over at my kind of a closing slide here, just as my contact information. So I'm U.S. Trademark Attorney Eric Kelly. I work with clients from all over the world and the U.S. I handle trademarks, as we've discussed throughout this video, but I also handle patents and copyrights. And further, with respect to, you know, the fees with trying to seek registration of a trademark, and I think this should be obvious, but I want to say it anyway. So if you do hire a trademark attorney to do this for you, you have to pay the attorney fee in addition to the USPTO governmental fees. And statistically speaking, you have a much greater likelihood of success if you do this process with a trademark attorney as opposed to trying to do it on your own, as it is kind of a tricky process. Here's my contact information if you want to reach out to me. In any event, I appreciate you taking the time to listen. Thank you. Bye-bye. Please subscribe to help me reach others about intellectual property matters. And here's some suggested videos on additional trademark issues that might be of interest.